You're listening to Two Bobs, conversations on the art of creative entrepreneurship with David C. Baker and Blair Enns.
Blair, what could we start off the next year with? What would be the most exciting, engaging topic we could think of?
Positive and uplifting.
I doubt if you could come up with anything more exciting than this, but what about talking about contracts and proposals?
I love that idea. And the impetus for this was you and I sharing some frustrations around contracts that we get asked to sign from time to time. And we decided, okay, there are lessons here that we teach, and we better start taking our own advice.
Yeah, I was frustrated because I got this contract a while ago that it just kind of was discouraging, disheartening, and I sent it to you, and you gave me great advice. You said, well, did you give them yours first? I got to thinking, I didn't. This also reminds me back when I used to do a lot of work for large corporations. I do work for in-house marketing departments. And I remember I got a contract. I'm not going to identify the auto manufacturer, but it was one of the top 4 in the U.S. And the contract came through. This is back in the days of fax machines, right? And it was 28 pages long. This was the contract for this $40,000 consulting engagement. And I started reading. I got through about 2/3 of the first page, and it was just so boring and so not applicable to me. I just crossed out every page, and then I faxed the whole thing back to them. That's kind of how I feel about contracts.
Cross out the page, sign it, and fax it back.
And send it back.
All right.
Yeah.
Love it. Yeah.
Yeah, and this is not legal advice. We should start with that, right?
Right.
You and I both know some folks that do this work, and they're actually competent, unlike you and I on this subject, like Sharon Torek, Candace Kirsch, Jeffrey Dermer, Michael Lasky. We'll put their contact information in the notes. Otherwise, we're just going to be talking as two schmoes here with some ideas about that. Would you start by telling us clearly the distinction between a contract and a proposal? Because we do both of those things. What's the difference?
Yeah. I've been saying these words for years. It's just so obvious, but I think back to my previous life in the agency world. I always conflated the two, and most of my clients, most of the listeners conflate the two. So the proposal is the words that come out of your mouth. Here's what we propose to do. Here's how long it will take. Here's how much it's going to cost. The contract is the document. The contract comes out once you have an agreement in principle. And as I said, in the agency world, we often confuse and combine those two things into this one mystery document called the deck that's got information about our firm. It's got pictures of the office dog and the espresso machine. It's got staff photos of us when we were all kids. It's got the background of the client's challenge as we understand it. It's got some free strategy. It's got some free creative advice. Then it's got a price and a place to sign and sometimes some terms and conditions. And those things never get signed, right? So we're confusing these things. And in the simplest terms, the proposal is the words that come out of your mouth, and the document is the contract. The document should not come out until you have that agreement in principle.
And by in principle, do you mean verbally or in writing in some fashion pre-contract?
I mean verbally, generally speaking. So obviously, there are pitch situations, there are larger firms and really competitive situations run by procurement departments where we're trying to change those rules and laws and bend the laws of kind of procurement physics in our favor by pushing back on all of this stuff and keeping the process more in line with what I've just said. The proposal is the words that come out of your mouth, the document's the contract. But from time to time, I acknowledge that there has to be some sort of written support for the proposal. But don't confuse that with the contract, like putting a place to sign on it, adding in your terms and conditions, etc. Keep the visual support for any proposal, which is an oral proposal. Keep the visual support as small as possible. In fact, the constraint that I love and we teach is keep your written proposals to 1 page. And there's pushback on that idea because you can't possibly communicate all of the details that you want to communicate in your proposal on 1 page, particularly if you're using options, if you're putting forward options in how the client can engage you. But by limiting it to 1 page, that constraint, you'll actually find it helpful, although it'll terrify you immediately, because the benefit of just accepting that you can't put everything on 1 page will force you to just treat that 1 page as a highlight or a summary of your different options. And the summary is just a little bit of visual support for the conversation. And then you will be following the rule or the guidance that the proposal is the words that come out of your mouth. You keep it at a conversational level. That will force you to become a better salesperson in that moment. So it is a helpful constraint to keep any written support for your proposal to just one page.
When I talk with people about confusion around how to protect themselves and so on, I'll use this phrase. I'll say, if there's too much fog around the scope, then do some sort of a diagnostic until the fog clears. And in your methodology, that's something that they are getting paid for, right?
Yeah, probably the majority of the time when you are closing on a piece of new business, so a client that you haven't previously worked with before, usually that first engagement is broken up into a first phase diagnostic. So the rule or the guidance here would be, if you have to do a whole bunch of work to write your proposal, you should get paid to do that work. And the way you get paid is you sell a diagnostic, a first phase in the engagement where you're paid to better understand the client's situation and make recommendations. So the outcome of a paid diagnostic is your understanding of the situation and the ways to move forward and your recommendations on how to move forward. And if you have to do a whole bunch of research, a whole bunch of work to scope and price in that way, then you should get paid to do that. And you sell some form of diagnostic, some form of research or on-site discovery, or, there's just an infinite number of different forms of diagnostics that you could sell.
And I call that paid prospecting, essentially the opposite of just writing a proposal with all kinds of detail in it. And I think as an industry, we've gotten away from that, although I still see it every once in a while. And if the proposal, to the degree that it's not one page, then you are sometimes flirting with the idea of doing some unpaid work. That's part of the point of this constraint. So when can you get excited about closing a new client? The contract comes after the proposal has been accepted verbally. Is it too soon to get excited about closing after they've said yes to a proposal?
That really depends on your firm, the size and nature of your firm, and the size and nature of the client. In the larger clients where you're dealing with professional buyers, and I'm a little biased towards those scenarios these days because I recently attended a marketing procurement conference. But in that type of world, you just need to understand that it's not over until everything is signed and you've received the first payment. It's a scenario by scenario thing where some parties will actually look to draw out that negotiation. Even after you think you've got an agreement in principle, like ready to sign, they'll come back and they'll just see that as kind of the beginning of the next phase of the negotiation. But generally speaking, smaller firms or smaller clients, or where you're dealing less with professional buyers and more with owners or executives of businesses, you can treat the contract signature as a close.
Okay. So now you're negotiating. The proposal's been accepted, often verbally. You're going into this. Who starts this first? And what's the advantage if the client gives you something to look at versus you giving the client something to look at? And I think this is a little bit the mistake I made recently.
Yeah. We've talked more than once about the anchoring effect on this podcast. And the anchoring effect is sometimes known as anchoring and adjusting, is the idea that the first piece of information on a subject is likely to skew the final decision on that subject. So when it comes to price anchoring, it simply means you put the big numbers forward first. So when you're presenting options, you lead with the biggest, most expensive option. If you don't anchor high, your client will anchor low. And it's this similar effect going on here. You get to this agreement in principle. So your proposal is accepted verbally, subject to working out the final T's and C's, terms and conditions. And then in that moment, once you have the verbal approval, you should see yourself as in a race to get your form of documentation, whether it's an MSA, Master Services Agreement, or just a one-off contract. You want to get your form of documentation on the table first. You want to anchor with your piece of paper. Because if you don't, like you just experienced, David, if the client puts a document on the table first, it's almost never perfect. It's almost never even appropriate, right?
Right.
I didn't ask you about the details of that contract. I've been there. I'm sure there's a bunch of stuff in that contract that's just not relevant to you and what you're being hired to do.
Right. Yeah. In fact, sometimes you'll see this in an NDA, for instance. Every single NDA that I've gotten from a client, which is what prompted me to come up with a simpler one that I sign before they even ask me to, and I give it to every client. But every once in a while, they'll come back with a much more detailed one. And every NDA I get says, and at our request, you will return everything that we have given you, including all copies. And I'm thinking, well, do these people realize that Dropbox and Google Drive and Box, they're making copies of everything, and I don't even have access to all those copies? So in the past, it doesn't even apply. When you say anchor high, you're not talking exclusively about anchoring price, but also terms and conditions as well, right?
Yeah, and in this case, I'm not talking about price at all. You would have covered that off already, although there might be some price negotiation that comes afterwards. I really am talking about the terms and conditions. The same thing goes with NDAs. There's some standard contracts that you should have, and those contracts should be favorable to you because your default assumption should be the client is going to open with a piece of paper, whether it's an NDA, an MSA, or a contract. They're going to open with a piece of paper that's entirely skewed to them. And then you're going to have to go back and forth. But what this anchoring effect says is that starting point, the point at which you start, that's going to affect the outcome. That's the beginning position that you have to counter against. And it's far more powerful if you are starting from your beginning position. So just understand that clients have NDAs, they have MSAs, they have contracts. And once you have an agreement in principle, they're going to put their document on the table. And what you want to do is you want to have standard versions of those three documents yourself. And you want to put your version on the table first and then have them have to counter against that.
Right. Even while you're on the phone, sending it to them, clack, clack, clack.
Yeah.
We're not in the business of writing all the specifics of contracts and so on, but we could illustrate a few of those here. Things like IP ownership and transfer, like who owns it and what happens if something comes up before they paid for it.
Let's just talk about that one for a minute because that's a really big one.
Yeah.
Because the standard client approach, especially, a lot of clients might be using kind of the ANA contract or MSA template. It's about 50 pages long. I don't remember if that one specifically advocates this, but the beginning position is typically that the client says, as soon as you develop IP, when working on our behalf, we own it. And that is just an unacceptable position.
Right.
And again, I'm not a lawyer, get some proper legal advice, but basically IP doesn't transfer, if it transfers at all, it doesn't transfer until you've been paid in full for it.
Right.
So that should be your starting point on that topic.
Yeah, absolutely. And one of the things that you do in a collection setting is that it's not then just about the fact that they haven't paid you what they were supposed to, about which there's some dispute, but they're using something that's not theirs, and that's under a different category of theft. So yeah, there's important things to think about here. And this is where you would work with your own attorney or one of the ones that we've heard of to come up with it. So then other things like terms, Eno Insurance. Now, most agencies don't have Eno Insurance. The only ones that do are the ones that bought it years ago and haven't thought about it, or because their clients demand it. Eno Insurance is something that you're never really going to get a claim paid back for, because if there's a dispute, then they're going to say, well, you have to have followed all of these procedures. You're going to have to pay for the litigation on your own. If you lose the suit, then you can go to your insurance company, and it usually never gets that far.
There are other forms of insurance, though, too. There's just general liability insurance, and some client contracts will ask for a huge amount of liability insurance.
Yeah.
And the guidance I've seen Sharon Torek give in a couple of talks is that you really should limit your liability to no more than whatever the total compensation that you're being paid by the client.
Yeah, general liability, usually they're asking for $2 million nowadays, all those things. Other things like, if there's a dispute, what do? Do we take it to court? Do we force it to go to mediation? Who gets to choose a venue? We don't need to get into all of that stuff, but obviously you'd think through this and decide what you want in your contract and keep it as simple as possible.
You're listening to Two Bobs, conversations on the art of creative entrepreneurship. Your hosts are David C. Baker of Recourses, author, speaker, and advisor to owners of expert firms, and Blair Enns of Win Without Pitching, the sales training and coaching program for creative entrepreneurs. For more information, go to twobobs.com. If you find this podcast helpful, please help us by telling a friend and rating us on iTunes. Thank you. Now back to David and Blair.
So when you have to respond to the client's contract, when they send it to you first or when they are reacting, walk me through this back and forth, this cadence here.
The textbook way to play this is for you to have standard documents and to put your standard document on the table first. You don't even have to modify it, right? Because again, it's just a starting point in a negotiation. And if you don't use yours, the client will use theirs. And again, they see theirs as just a starting point in the negotiation. So that's the textbook way to do this. But the reality is, just like your situation where not so long ago you found yourself, you've got standard documents, but the client went and put one on the table and you look at it and it's ridiculous. It's a little bit, I don't know about disheartening. It kind of sucks the wind out of your sails, right? Because it's like, oh my, here's one more battle I've got to fight.
Yeah, I thought I was an expert and now I'm being treated like somebody else. It does. It gets you like less excited about the engagement when you see the contract. And that's not a good thing.
Yeah, and that's one of my beefs with marketing procurement in general is like, the marketing department in these large companies, they're working very closely with their agencies. They're almost always seen as important strategic partners. They're helping to drive growth and other change across the organization and certainly in the marketplace. And then procurement comes along and treats them like a vendor. So even the marketing department kind of values the agency's expertise, respects, values it, and is willing to pay for it. All that goodwill goes out the door. It's allowed to be eroded by the procurement department. This is a bit of a tangent. I've got a real bee in my bonnet. Man, I sound like I'm 80 when I use that.
Oh, I love it when you
I got a bug up my ass. How's that? I've got a bug up my ass about marketing and procurement. I'm going to write about this or we're going to do a podcast about it. I'm so struck by how bad it is, like how wrong these people are getting things and the detrimental effect that they are having on the quality of the marketing, the creativity, and the innovation in their companies. I think it's just having this big carry-on effect on their businesses and the agency world. So we'll come back to that. Now, what was the question?
I don't know, but
we'll come back to that in a future episode when I've calmed down a little bit.
You need to go to your therapist a couple times before we come back to that topic. Well, it's about being treated as a vendor and how disheartening that is.
Yeah, and you were saying, okay, so you've got to respond. And you were in this situation recently, and it kind of sucks the wind out of your sails. But you do have to respond. And the way you respond is you pull out your red pen.
Okay.
Actually, let me back up. The proper way to respond, if you have standardized your own documents, is before you even open the document, whether it's the NDA, the MSA, or the project contract, before you even open what the client has sent you, you realize, I've made a mistake here. I haven't put my document on the table first, and you send yours and say, oh, thanks, I'd meant to send you mine. I haven't looked at yours yet. Have a look at mine. I'll have a look at yours, and then let's have a conversation. So at least you're attempting to counter that anchoring effect. And then now you're in a negotiation. And ideally what you want to do, somebody's going to have to write over top of somebody else's, like whether it's done digitally in Adobe Acrobat or whatever, or with the good old-fashioned red pen. I love a red pen and then scanning it and sending it back. Somebody's going to have to write over somebody else's contract. Ideally, the client's writing over yours, so you have effectively anchored. And if you can't do that, and if you have to write on theirs, then just cross out everything. But I've had similar situations where you just end up crossing out 2/3 of everything in there. And that's just a negotiation. So get your document on the table first. If one shows up in your inbox before you've put yours in the client's inbox, then send yours before you open the client's. When it comes to do whatever you can to see that you're negotiating from your document. And if you can't, use your red pen liberally. What I would say is, especially to the smaller agencies or younger agency principals who are encountering this for the first time or the first few times, I've had lots of calls from my clients over the years where they've just called in a panic. Like the first call is, oh my God, you won't believe I just closed some Fortune 500 company, biggest client we've ever closed. And then the next call is a panic. Oh, I just got the contract and I can't believe it. It's totally onerous. It's just untenable. And I just calmly say, get out your red pen. Okay, read it to me. Cross it out, cross it out, cross it out. And that's what you should do. Just cross out everything. It's a negotiation. Don't get attached to it emotionally. Just cross out the stuff that doesn't work. Cross out the 120-day terms and put your terms in 30, whatever it is. Cross it out, send it back. If you're not dealing from a position of your own document, then you really have to be just liberally eviscerating the client's document.
Are you okay if we keep talking? Do you need to take a walk first, or are we okay? I don't want to stretch your heart or anything.
It's been like 4 or 5 weeks since I've been at this conference, and I still haven't calmed down.
And one of the things that probably makes sense, I would guess, is that you'd want to have somebody who's objective and patient, but also has a ruthless streak to them, do the negotiation on your behalf, especially if you're the principal, you've got other things to worry about. We want you leaving the cave, going out, killing something else, and dragging it back. How do you talk about things like payment terms? How do you remind them of some of the leverage that you hope to bring to the table around cost savings and all that sort of stuff?
If yours is a small business, I think you just counter their ridiculous terms. And 120-day terms are ridiculous. I don't care who you are, what business you're in. It says a lot about your suppliers if you're asking for 120-day terms. I'm hearing 150. I've even heard 180-day terms.
Mm-hmm.
So you need to push back on that. And if you're a small business, there's no shame in saying, listen, we're a small business. Our terms are 30 days. We're not your bank. We're not in the banking business. You want to negotiate on something somewhere else? Maybe we can find some more common ground. There's no common ground here. These are our terms. I got this from Tom Kinnaird, who used to run procurement at WPP, and he now runs, I think it's Kinnaird Consulting. He trains agencies in how to negotiate with procurement. And he says there's really 5 main forms of savings that the client's procurement team is looking for. And I would say not just procurement, any client. So the first one is cost. So just the price that's paid. So you're prepared to negotiate on that, whether you're just decide in advance, are you willing to give on that or not? And the second one is cash flow, which is terms, the payment terms. With a small, good client who is going to be a good partner and is going to recognize and value your expertise, who maybe has affordability issues, I think extending more favorable terms is a perfectly legitimate negotiating point as a way to help a client, say, kind of afford you when they say, well, we recognize the value of this, we just can't afford it. Then terms is a great way to kind of bridge that gap. Extending terms to the world's largest companies is ridiculous. So I think that cost and cash flow, or price and payment terms, I think those are things that you generally don't want to give on. Maybe you'll end up with a little bit of price negotiation, but the next 3 areas are the ones where you really want to do the negotiating if you are negotiating. And the next one is value add. So what can you throw in for free that isn't going to cost you much or anything? The next one, or the fourth one, is knowledge transfer. I think we've talked about knowledge transfer before. A lot of clients really value knowledge transfer, the idea that you're going to go into a client organization or work with a client organization, and by doing whatever you're contracted to do, you're going to improve the ability of the client side creative or marketing team to be able to do that in the future. Now, if we don't talk explicitly about knowledge transfer and that the client values knowledge transfer and is going to get knowledge transfer, then it's always going to feel like the client is stealing it from you. So they value it. You need to put it on the table and say, we do this for you a couple times. It's going to improve your people's ability to do this in the future. And if that's important to you, we can actually build in a little bit more training for your people. So we will undertake the engagement with the explicit understanding that part of our objective is to increase your ability to do this in-house in the future. And then the 5th thing that they value is risk reduction. And there are various types of risk. There's financial risk, there's kind of personal risk, there's opportunity cost, there are other forms of risk. So those are the 5 things that the client values. So price, terms, something for free, train their people, or risk reduction of various kinds. And those first 2, I think you don't move too much on those things, especially terms from big clients. Don't be pushed around by them. And if you need to find some common ground, if you need to give something up, give it up in the last 3 categories.
Those are great reminders. As we wrap this up, I want you to talk a little bit about this notion that we've already spent a lot of time on in the past, but it's so relevant here again, and that's the notion that you talk about frequently about investing in the sale. In fact, we did a whole podcast on that. It all boils down to this. Remember that one? But investing in the sale here could also mean deciding when you're going to care and how much you're going to care. For instance, one example of that would be when they draw it out, right? When they try to wear you out, and meanwhile, you've literally invested so much time that you might be tempted just to give up, right? That's legitimate here?
Yeah, it is legitimate. Your larger clients and professional buyers in particular, they draw the process out. They try to get you overinvested in the sale. They draw the contract negotiation out. There's all kinds of stories of contract negotiations going on for a year. So just as a matter of policy, you should never begin working on a new client before everything is signed off and you've received the PO. You've been paid in advance or have a purchase order for the initial payment. Never, as a matter of policy, you should never violate that. And they'll try to get you to violate that. They'll try to drag it out while getting you to start the engagement. And as soon as that happens, all your negotiating power is gone. So make sure you don't do that. You mentioned a little while ago the idea of having an impartial third person negotiate for you. If you've got a full-time finance person, that's the ideal person. They're not emotionally attached to the work. It can be somebody else in the team if you don't have a full-time finance person. If you've just suddenly closed a big deal, bigger than you usually close with a client that's bigger, and you're finding the contract negotiation part more onerous, you should think about hiring somebody on a temporary basis, on a contract basis, to negotiate on your behalf. I think too many agency principals in particular, especially if they come from the creative side, we fall in love with the work. This sunk cost bias sets in because we overinvest in the sale. Loss aversion bias kicks in. We feel like we've won it already. Now we value kind of losing something about twice as much as we value winning something. So once we feel like we've won it and now we're on the verge of losing it, we're going to raise our level of stupidity in terms of the things that we're going to do to try to save the business. So be careful of all of that. There's all kinds of stories I've heard from my clients. I heard one a couple of weeks ago. It almost broke my heart about this agency principal from the UK saying we'd competed for this really big piece of business. It was the most perfect brief I'd ever seen. The client had lots of money. We competed against some of the hottest agencies in the UK. We were told we won, and then the client showed up and said, the fees are half of what we said they were. Take it or leave it. We're going to the next agency.
What'd they do?
Well, he said, we have to take it. And I've written an article about a similar situation, and I forget what it's called, but we'll post a link in the show notes. 2 different agencies in exactly the same situation, and one said, well, we had no choice. We had to take it. And the other one pushed back and said, screw you, we're walking. And then in that second scenario, the client called back later and said, okay, you can have it at full price. That's usually a negotiation tactic. But I was surprised when this agency principal told me the story a couple of weeks ago. He did such a good job of building up the story of how great a client was. And when he told me the negotiating tactic at the end, I kind of lost it. I just absolutely lost it. I felt his pain. And he said, what would you have done in that situation?
Yeah.
And the proper answer should have been, I would have said, I'll get back to you. And then I would have calmed down. And then I would have called back and said, we'll pass, in some version of that language. But what I said to him was, my reply would be a 2-word reply, and then I would look that person in the eye and say, you have become my project. I'm going to make your career a project of mine. I'm going to follow your career for as far as you go, for as long as you're in this business, and I'm going to do everything I possibly can to destroy it.
That would be an alternative to relaxing.
That's me. I'm willing to blow off a nuclear bomb to solve a small problem, right? It's a character defect, and it's not the right answer. It's not the right answer our listeners should give. The right answer is, I'll think about it, walk away, call back and say no. I think in that situation, when procurement calls that playing chicken, right? And maybe they really will go to the next agency, but if they do, then the marketing people never really valued you to begin with. It's likely they're not. It's likely they're going to come back to you. And I think in those situations, you should die with honor.
I was working with a firm in Canada this year. They work for a particular segment that's really slow moving, and it takes a long time to get all these contracts written. And it was a very similar story to what you just related. And they told me that in their typical engagement, they are halfway through the project before they finish negotiating the price. And they asked me what I thought about that, and I told them in not all that kind language. And then I tried to explain how they'd lost all their leverage, and they acknowledged that. And then I just didn't know what to say at that point. It was like, I can't help you. If you're willing to spend 2 months on a project unpaid, what could I say that would change your life and change your thinking? Because you don't need more information from me. You have the information, and you had it before I even came into your life. What you need is some courage, right? And I think that's part of what we're talking about here. As you were talking earlier, I was thinking to myself, you know what? Some of our listeners really ought to just get out of this business entirely. If they're going to be compromised to this degree, they ought to just get out of this business. I'm not talking about a huge percentage of them, but maybe 1 or 2% should, if they keep getting steamrolled over the issues like this.
I have good clients that we've trained for a long period of time that do a lot of things well. And then I hear from their coach, no, they routinely start work on a new engagement before the price has been agreed to. And I think that's what you learn in day one of, whatever variation of business school, listening to this podcast. I recognize most of our listeners don't go to business school, but it's one of the first lessons you learn. The idea that somebody would be in business for years and still be making that mistake, I'm dumbfounded by it. To your point, if you can't draw the line on that issue, good luck with everything else downstream.
And what it comes from is a panic that we don't have a positioning that's leading to enough opportunities, and my people are just going to be sitting around, so they might as well be sitting around doing something that we might get paid on. That's how they think about that. And yeah, it's tough. Well, we have just finished an episode that we could retitle, Why Blair and David Are Not Attorneys, and Why They Do Have Therapists.
Yeah, I don't have a therapist, but it's clear I need one. This is my therapy.
Thank you, Blair.
Thank you, David.
Thank you for listening to Two Bobs with David C. Baker and Blair Enns. Subscribe and learn more at twobobs.com. That's the number 2, BOBS.com.